Good evening, everyone. This is Sherry Pasternak speaking, and I'd like to welcome you to this Idle No More and Defenders of the Land co-presentation, a webinar presented by Mohawk policy analyst Russell Daibo called Turning the Tables, Self-Determination, Not Termination. Before we get started, I'm just going to give a brief introduction to Russell Daibo before he begins his presentation, and I want to let you know some of the ways that people can get involved in terms of interacting with Russell and asking questions and getting clarifications on some of the information that's going to be presented tonight. So there's a number of ways that you can ask questions. One is through the Facebook event page. If you post questions there, even if you have a thought at the beginning of the presentation or in the middle or the end, that page is going to be monitored constantly throughout the presentation. So we'll take note of that and hopefully get to the questions at the end. Also on the YouTube page, there's a place to post comments, and that page is going to be monitored as well. And there's also a Twitter hashtag that you can use. That's hashtag #TurnTheTables. So that's plural, turn the tables, where you can post comments as well. So we encourage you to use those platforms so that we can make this a more interactive discussion and dialogue. So everyone can get the most out of this presentation. The other place we post information about termination policies where there's already some information up and where there'll be information about campaigns, ongoing campaigns, templates for letters, draft resolutions, and really it will be whatever we make of it, is on the Idle No More page. So go to www.idlenomore/turn_the_tables. That's a place where we're going to post information about the termination policies and also where we'll be posting a record of this webinar. So you'll be able to watch it again if you miss anything. This video will be archived there. So I'll repeat this stuff after Russell speaks as well, in case you missed any of it, because it's a lot of information. And I'll see if we can maybe post that information on the Facebook page and on the YouTube page as well, so for reference throughout the discussion. And without further ado, I'll introduce Russell so that we can get started on the presentation. Well, it's an honor for me to introduce Russell Daibo tonight. He's been a mentor to me for about 15 years, which means answering an endless stream of questions that I've had. And the reason why he's such a valuable mentor to have is because he carries such a wealth of information and knowledge that you actually can't find in books. And the reason for that is because Russell's been working on the ground and in the trenches and in the back rooms for decades now, and he really has an intimate understanding, both theoretically, historically, and then practically in terms of his experience, about what colonialism looks like in Canada as well as the United States. He has a comparative lens. And what he really taught me is that the front lines of Indigenous struggle and colonialism in North America are not always on the blockades, that there's a silent war being fought in the back rooms at cabinet level and within the civil bureaucracy that's being waged through policy, legislation, and all these kinds of administrative forms that are really kind of invisible to the naked eye in many ways, that Russell makes visible for people, that Russell really brings to the forefront and analyzes and explains and really kind of shows how these tools are the kind of the means by which colonialism unfolds in a settler colonial context in an advanced capitalist society. And that's not to say that he ignores the intense militarization and the real physical war that's being waged against First Nations, but he contextualizes that militarization as being a form of compliance for bands, nations, and communities who step out of line and refuse to conform to these termination policies that really have a consistent history over the last 200 years of Canadian history. Even despite whatever limited legal victories have been won, and maybe we'll get a chance to talk about what Shackleton means in light of termination policies as well a little bit later on. I'll just say a few words about myself in terms of an introduction. I'm a non-Indigenous person who's a first-generation Canadian, and I believe in my responsibility as a Canadian citizen to help create conditions for the multiplicity of forms of self-determination being demanded by Indigenous communities. And part of that effort is to create a broad base of informed support among non-Indigenous people about Indigenous issues and to work in solidarity with Indigenous peoples in these efforts. So in that, towards those efforts, I've been part of solidarity groups like Barrier Lake Solidarity. I'm an ally in the Defenders of the Land Network. I was part of a group called the Indigenous Sovereignty and Solidarity Network, a mixed group of Indigenous and non-Indigenous people based in Toronto. We organized Indigenous Sovereignty Week, which happened annually for about 4 years and was an important local event. And I've worked with I Don't Know More Toronto to organize a couple of conferences, Nation to Nation Now, and Building Unity to Action. And I also work with the Indigenous Network on Economies and Trade, looking at the political economy of risk generated by Indigenous resistance and assertions of jurisdiction over lands and resources. All this is volunteer work supported through my academic activities. So without further ado, I'd like to introduce Russell Dibo and give him the floor. He has a presentation prepared for us. Again, if you have any comments throughout, please feel free to post them on the Facebook page and on the YouTube page.
Thank you, Sherry. That was a very kind introduction, and I think a good overview of the content of what I want to talk about tonight. I'm using a PowerPoint because that helps me focus and make sure I'm hitting the points that I want to make. Also, I guess we're going to make it available after this webinar for people that want copies of it as well. So really, this turning the tables, self-determination, not termination webinar or campaign really goes to the heart of what is Canada's First Nations termination plan. I know a lot of people are asking that. What is termination? So I'm going to attempt to try and address some of those questions tonight on this. So if I could have the next slide. I guess the main points I want to make is before Europeans came, our creation stories place us here on Turtle Island, which is the North American continent. Not from somewhere else. I know there's the Bering Strait theory, but a lot of that's been disproved now. But our own creation stories place us here. We were given our original instructions by the Creator on how to live within the natural world on Mother Earth, whatever Indigenous nation we come from. We have our own teachings that we carry, our own customs. Whatever Indigenous nation we come from, we have inherent rights, which are pre-existing rights, and along with those rights come responsibilities. As I've often heard, that it's not just about rights, but it's also about our responsibilities to the natural world, to nature. The next slide, please. So the parts of the presentation, I just want to go over about our common colonial history that we share here in Canada. Then I want to talk about what is termination and what are the termination tables and who's negotiating. And then I want to end off with what can you do if you're interested in doing something to try and stop Canada's termination plan. Next slide, please. So this is on our common colonial history. First point I want to make is Canada bases its territorial integrity and assertion of sovereignty over Indigenous nations by continuing to rely on the racist and outdated notion of the doctrine of discovery. This is a doctrine, or a belief that the Europeans had amongst themselves when they discovered the so-called New World, that the Christianized nations would be able to claim these nations on behalf of their sovereigns by planting a flag. And in Canada we had John Cabot doing that out on Newfoundland, but we also had Jacques Cartier sailing up to St. Lawrence, and Samuel de Champlain, and we had other explorers, and they were all basing their explorations on discovering new lands on behalf of their European powers. Canada still relies on that today. Next slide, please. So, in our first encounters with European explorers, priests, traders, and early settlers who were often in forts, along rivers, like Quebec City and so forth, and Toronto and so on. This was the start of the historic colonization process. Regardless of what Indigenous nation we were from, or what our identity was, we were referred to as Indians. And because Europeans are so outnumbered initially by our Indigenous nations for the first 300 years in what's now Canada, representatives of those European sovereigns negotiated treaties of peace, friendship, and economic and military alliances with us. Otherwise, they would have never been able to move from the ocean shore or the river shoreline into the interior of the country. Next slide, please. By the time 1850 came along, settlement was proceeding, in what was called Upper and Lower Canada and the Atlantic regions. Indians, as they called us, were increasingly seen as a barrier to the development and settlement of the country, and a burden to the colonial treasury, because they'd been giving us presents and maintaining, trust funds and lands, that through agreements that they'd entered into from the early contact period. So about 1850, that's when they started to move towards assimilation and the civilization in terms of their objectives in these early laws that they were starting to pass over us. Increasingly, the spirit in terms of the treaty relationship, in the early treaties, were contradicted and ignored at this period. This is about when the change occurred, when we started to get outnumbered. Next slide, please. So by 1867, which was Canada's first constitution, the British North America Act, that first constitution gave the federal government responsibility for Indians and lands reserved for Indians. And it was through that constitutional authority that the federal parliament passed the Indian Act, which consolidated all those laws from 1850 on up to 1876. And this is the original termination plan. And this is where the Indian Act that was adopted in 1876 maintained the contradictions. On the one hand, protecting us from settlers and settlement on reserve systems, but also to assimilate us, basically using reserves as holding tanks until we could be assimilated into the general population. So we have to keep that in mind. This was the original goal of the Canadian government as a colony. Next slide, please. So here you have a picture of the treaties. You can see there's the treaties of peace and friendship along the Atlantic region there. There are the treaties of peace and friendship amongst the Seven Nations Confederacy in what's now Quebec and parts of Ontario is not listed here, though it does exist. You can also see in Ontario the early treaties that occurred there, right up to the Williams Treaty in 1923, which is the last historic treaty in Canada. You can see the numbered treaties across the prairies. These treaties were entered into and promises were made. and established the basis of, you know, the treaty law in Canada. Next slide, please. But as we've seen, you know, like I said, from the 1850s on, the treaty relationship was contradicted and ignored, and Ottawa, which was the center of Canada, the government, applied the terms of the Indian Act instead. And the Indian Act was basically, it's still in place today, and that's the law that Canada uses to flow monies for programs and services through to accomplish our goals to assimilate us until we're not around anymore. So there is a big contradiction between the Indian Act and treaties. In 1968, Pierre Trudeau was elected as Prime Minister, and Jean Chrétien was his Minister of Indian Affairs. We're still dealing with the effects of these two individuals in terms of Canadian policy today, Canadian Indian policy and the Constitution. Next slide, please. They proposed a 1969 white paper on Indian policy. Basically, that was, you know, it was 100 years since the Indian Act was passed in 1876. When they formed government, they figured that Indians were assimilated, and it was time to finish off the process by repealing the Indian Act and amending the Constitution to remove any reference to Indians in the treaties, get rid of reserves, basically, you know, turn Indians into Canadians and reserves into municipalities, and there would be no more Indians. And they said that equality was what was holding us. We didn't have equality because of these special laws, and we had to get rid of the legal distinctions between Indians and the rest of Canadians to advance ourselves economically and socially. Next slide, please. So when the white paper was passed, it led to the red paper and the brown paper, and, you know, the modern Indian organizations were formed. You know, the National Indian Brotherhood came before the Assembly of First Nations. The provincial organizations like the Union of Ontario Indians, the Union of BC Indian Chiefs, the Union of Nova Scotia Indians, Manitoba Indian Brotherhood. All these organizations formed by the chiefs to fight the white paper. So throughout the 1970s, that was the case. But in 1980, Trudeau came to the chiefs and said that he wanted to bring Canada's constitution back. So he wanted a new constitution to replace the old constitution from 1867. And there was a big debate about, you know, whether, you know, First Nations should be part of that or not. In the end, quite a few First Nations said, we better be part of the Constitution, the new Constitution, because if we're not in there, they're going to ignore our Aboriginal treaty rights. So they did include Section 35 in there, which says the existing Aboriginal treaty rights of Aboriginal peoples are hereby recognized and affirmed. And this is the picture of the Queen signing the new Constitution into law on April 17th, 1982. And there was a series of constitutional conferences that were supposed to define politically what the meaning, what rights were going to be protected in Section 35, but those talks ended in failure without an agreement on what rights are included in Section 35. So there's legal and political uncertainty about the content, the scope and content of Section 35. What does it mean? Next slide, please. So it fell to the Supreme Court of Canada to start defining what does Section 35 mean in law. And in 1990, and through a string of court cases, you know, dealing with treaty rights and Aboriginal rights, they started to lay out legal tests, which cost tens of millions of dollars to prove or to sustain in court on Aboriginal treaty rights about what the meaning of Section 35 is, the legal uncertainty. But basically what the court has said is that in Sparrow in 1990 that Section 35 is not absolute. It can be justifiably infringed for valid reasons like the general economic development of settler governments like provinces, you know, hydro, mining, forestry, and so on. So they also have said the burden of proof is on the groups who are asserting rights to have to prove it. There's two key legal tests for Aboriginal rights and Aboriginal title now. The Aboriginal rights test is in Vanderpeet, and it has to be, if you say you have an Aboriginal right, it has to be a custom, practice, or tradition you did at the time of contact or before contact with Europeans. So that's a high burden. If you're arguing that you had the commercial rights to do something, the burden is on you to prove that you did it before contact with Europeans. Aboriginal title has a test, now most recently with the Chilcotin case. You know, they basically say you have to show that you occupied the land, that you did it continuously, although it doesn't have to be unbroken, and that it was exclusive, that it, you know, you use that land and other indigenous nations didn't. And they lay out other principles in there, but the point is that Section 35, which was supposed to be politically defined, has become legally defined, and the courts are laying out you know, legal principles and tests which are making justice really beyond the costs of most communities to be able to afford because they don't have the money to go to court and sustain constitutional challenges. The next slide, please. So in 1987, the First Ministers' Conferences on Aboriginal Matters, you know, to define what was in Section 35 ended. Moroney, Prime Minister Moroney, Conservative Prime Minister, had started negotiations secretly with the government of Quebec to recognize Quebec as a distinct society. He had an amending formula to amend it. He needed 10 provinces with 50% of the population to adopt the Meech Lake Accord, which was a constitutional amendment, by the end of June 1990. Elijah Harper, who was in the Manitoba legislature, under their rules, they needed unanimous consent in the legislature for that law to be introduced, and he said no. Famously said no, holding his eagle feather, and he basically ran out the clock on Meech Lake, and so Quebec didn't get their distinct society constitutional amendment that they were seeking because of Elijah. But Elijah was supported by many First Nations people who felt that Aboriginal and treaty rights should have been addressed first before Quebec's interests. Next slide, please. So a month after, you know, the Meech Lake Accord died, a SWAT team invaded Gunnesadage, and my community, Gunnawage, supported Gunnesadage because they were attacked, you know, with weapons, and there were women and children in the pines in Gunnesadage. This is a picture of the army landing on an island by my community, right by the center of the village, and people thought they were going to cross the bridge and go right into the village to occupy it, and so people came out and basically got into hand-to-hand combat with armed soldiers. You could see the guns strapped on his back. Men and women both got into basically fist fights and drove the army off the island. They had to retreat onto their helicopter and take off. But that standoff between Mohawk communities in Quebec and the Quebec government lasted 78 days, and it didn't really resolve the land issue in Gunnesadage that's still outstanding after all these years. But it also did signal that Canada, the Canadian state, was ready to say that there's limits to self-government and land rights in Canada because the Mohawk communities were asserting land rights and basically sovereignty over the territories. So the Army was there to challenge that as well. Next slide, please. So after the Moroney government lost the election, actually he had stepped down, and there was a federal election, and I think there was like 4 Conservative members of Parliament left. Jean Chrétien came in with a majority, and basically from 1993 to 2006, he tried to ram different legislation down. He, in 1995, he adopted the Aboriginal self-government policy, which was supposed to recognize the inherent right to self-government, but in fact it doesn't. It's a policy that many groups are negotiating at under the table, and it's set up to convert Indian bands into municipalities. That's basically the purpose of that, is to say you have local government powers and federal and provincial powers will dominate over First Nation powers. So that's the whole purpose of that policy. And as you recall, Jean Chrétien was the Minister of Indian Affairs in the 1969 White Paper. as Prime Minister, he tried to push an Indian Act amendment package through in '96 after that self-government policy was pushed through without consulting First Nations. He tried to push through the First Nations Governance Act in 2002 to about 2004. He had a Specific Claims Act. He had a suite of legislation similar to what the Conservative government's ramming through now through Parliament. The point is that Jean Chrétien and Paul Martin, who did the big Kelowna Accord thing, really my view of that was Kelowna was, a pre-election stunt because, the government fell about a week later after the Kelowna meeting occurred, and nothing was secured. He waited to the last minute to bring that forward, and they're using that to try and get reelected now. The Liberals that, although now Justin Trudeau has said that there won't be. He's openly said there won't be a Kelowna Accord because they can't afford it. That was when there was a surplus with the government, and there isn't a surplus now. So the Liberal governments haven't been helpful to us, although a lot of people are flocking to them now and to Justin Trudeau. But their record doesn't look good for First Nations. Next slide. So in 2006, Harper got in with a minority government, and he didn't get a majority until later on, I believe in 2011. Sean Atleo, National Chief, had entered into a joint agreement with the Harper government trying to work together. That led to this Crown First Nations gathering in January of 2012, where there were a number of commitments that Harper made, including that he wouldn't amend the Indian Act, and after that he introduced legislation through the back door through private members' bills to amend the Indian Act. He's pushed through the Matrimonial Property Act, a number of bills, all of which were done unilaterally without consultation and are designed basically to assimilate First Nations. And so that Crown First Nations gathering really wasn't anything more than a photo op for Harper and his government. Next slide, please. A year after that Crown First Nations gathering was this January 11th meeting in 2013. There were about 4,000, no more demonstrators outside of the building where this meeting was taking place. But in this meeting, the Assembly of First Nations went in to see Harper with 8 demands. Harper rejected them all. He also refused Chief Spence's request to have the Governor General present at the meeting, so she didn't attend. Many others boycotted this meeting. The only thing Harper agreed to coming out of the meeting was to create 2 senior oversight committees, one on historic treaties and one on comprehensive claims, or so-called modern treaties. Both those, the Assembly of First Nations last December rejected the Treaty Senior Oversight Committee. They pulled out of it. The Comprehensive Claims Senior Oversight Committee, we're not sure what's happened with that because Jody Wilson-Raybould was dealing with that through the Assembly of First Nations. My understanding is Harper got mad when he found out that she was going to be a Liberal candidate and refused to deal with her. So that process with AFN hasn't gone anywhere, particularly since Sean Atleo resigned. The Assembly of First Nations seems to be in disarray now. And they were dysfunctional before that. Anyway, this meeting really didn't produce much, but it shows you how Ottawa decides things and how some of our leaders, show up here at this meeting. There were about 30 of them that showed up to meet with Harper. Nothing really came out of it, though. Next slide, please. So, what is termination? Basically, the way I see it is the old Constitution, Section 9124, was what colonized us. That's what created the 2 orders of government, the federal and provincial orders of government. The provinces had jurisdiction over natural resources. Indians and lands reserved for Indians under Section 9124 were just considered a subject matter of the federal government. They moved us on reserves and took our lands and resources. They stole them. And that's why we've become impoverished and controlled by the federal government ever since then. Section 35, which recognizes and affirms our Aboriginal treaty rights, basically the government that was supposed to be our way out of colonization. The government, like I said, those tables in the 1980s we were supposed to have a political agreement on what the meaning of Aboriginal treaty rights in the Constitution were, what's protected there. Those talks ended in failure. The courts have taken over, and the governments have taken advantage of the legal and political uncertainty by offering to negotiate under their termination policies of comprehensive claims and self-government. So really, I guess the main point here is that in the past, under Canadian law, they didn't have to ask for Indigenous consent. They could unilaterally extinguish Aboriginal treaty rights according to Canadian law. But as of the new Section 35, they have to have Indian consent. So that's why they're pushing more and more for negotiated agreements and ratification by community members to those agreements that the leadership are negotiating. So it's a conversion process of our historic rights for these new rights, and under our new rights, they're basically emptying out Section 35 of any real meaning. And at the constitutional table, Section 35 was talked about by our Aboriginal leaders as a full box with all of our rights. The government said, no, it's an empty box, and we'll fill it up with agreements after you negotiate with us. And that's why those talks in the 1980s ended in failure, because there was no agreement on that. So now, you know, with the courts laying out these legal tests and the government policies are saying, okay, come and negotiate with us, we're waiting for you. That's what they want, is, you know, groups to sign off under Section 35 under new agreements. Next slide, please. So termination means ending the pre-existing sovereign status and rights of Indigenous nations through the Federal Indian Act legislation as amended. Because there's a number of bills that Harper's come forward on where he's promoting individual rights over collective rights. This Financial Transparency Act, some may think it's a good thing, but it's a piece to a broader puzzle, including the Matrimonial Property Act, to bring in provincial law onto the reserves around that issue. It really is property issues because, you know, the objective is to get rid of reserves in the long run. You know, we have the Indian Replacement Act, Indian Recognition and Replacement Act, that is a private member's bill by Rob Clark out of Saskatchewan, who says he's a First Nations person and he has a right as a member of Parliament to bring that in. But all of that is tied together in a suite of bills which are designed by legislative bureaucrats in Parliament under objectives set by Cabinet. And it's not for our benefit. It's basically to assimilate us. So it's going to be a whole new Indian Act once all these bills pass. And if you want out of the Indian Act, you know, it's basically you go into comprehensive land claims and or self-government final agreements. And those agreements convert First Nations Indian municipalities, reserves into fee simple lands, and extinguish our inherent Aboriginal and treaty rights. That's the objectives of those agreements, and that's what they want to get sign off on and people to ratify. Next slide, please. In Canada, this termination plan mirrors the United States Indian termination policy. Indian termination was the policy of the United States from the mid-1940s to the mid-1960s, and the belief was that Native Americans would be better off in assimilated as individuals into the mainstream American society, similar to what you know, Harper's suite of legislation and these agreements are doing up here. In practical terms, the policy terminated the U.S. government's recognition of sovereignty of tribes, trusteeship of Indian reservations, and exclusion of Indians from state laws. Native Americans were to become subject to state and federal laws, as well as tax laws from which they had been exempt. Next slide, please. So, like I've said, the Harper government's implementing this termination plan through two tracks. One is this modern amended Indian Act, and through negotiations, self-government and comprehensive claims final agreements. Next slide, please. So what the federal government wants First Nation communities and peoples to sign off on is they want concessions in writing in agreements. They want to get First Nations consent to the extinguishment, which they call modification of Aboriginal title, or the non-assertion of rights. They want to get First Nations to sign off on the legal relief of Crown liability for past violations of Aboriginal title and rights. That means that, you know, they want to pass for the wrongs that they've done. They want to get a legal release of that so that they can't be sued by future generations. You know, they want a one-time deal where they're absolved of any past wrongs. They want to get First Nations to accept the elimination of Indian reserves by accepting lands in fee simple. Some groups in Canada have already done this. There is a proposed First Nations Private Ownership Act that Manny Jules has been proposing along with Tom Flanagan on behalf of Prime Minister Harper. They want to get First Nations to participate in removing on-reserve tax exemptions. Next slide, please. They want to get First Nations to respect the existing private lands and third-party interests, and that means you know, the alienation of the lands, Aboriginal title lands, without any compensation. You know, they just want to basically for First Nations to accept, you know, what has been taken away in the past, the lands and resources. They want to get First Nations to accept to be assimilated into the existing federal and provincial orders of government. You know, to accept the old constitutional structure of the British North America Act. That's what they want us to assimilate under. They want to get First Nations to accept application of the Canadian Charter of Rights and Freedoms over governance and institutions in all matters, and basically that's saying that they want individual rights to trump collective rights. The Charter was not supposed to affect Section 35, the Aboriginal treaty rights, which are recognized and affirmed there. But they're trying to undermine, you know, the Constitution through the back door by getting agreements to concede those constitutional rights. They want to get First Nations to accept funding on a formula basis being tied to what they call in their self-government policy own source revenue, so that as a First Nation community raises revenues, you know, through economic development companies or users fees or anything like that, they're going to reduce the amount of funding through federal transfer payments. So you're not going to get ahead. You know, it's basically keeping you in a situation where you're always dependent on the federal transfer payments. And any money you generate locally will be, they'll take that in consideration and reduce the levels of funding. Next slide, please. So for cash and land, you know, under comprehensive claims, they don't give compensation. They do give some cash and land, and there is a formula, and the formula is it's $25,600 per head and 9.3 hectares or 23 acres per head. And you know, that's part of the exchange in a modern treaty of giving up your Aboriginal title, extinguishing your Aboriginal title to like 95% of your land and accepting maybe municipal lands. But that's the amount of money that's given. So it's not compensation for, you know, all the minerals and forests and wildlife and everything that's been taken off the land, you know, since Aboriginal title was there. That's not what the comprehensive claims policy does. So it's very little money in exchange for giving up your title and rights. Next slide, please. So what are the negotiating tables and who's negotiating? Next slide. Here's a map of the modern treaties, the final settlements. The James Bay Agreement was the first one in northern Quebec. That was in 1975. That was before the 1982 new Constitution came in. But they amended the Constitution in 1983 to say that for greater certainty, any land claims agreements that have been settled or may be settled are treaties within the meaning of Section 35. So these have constitutional status, these modern treaties or land claim comprehensive claim settlement agreements. And you can see most across the north of 60 that's mostly where they've settled, where Aboriginal title has been extinguished through these modern treaties. The Nisga'a, the Yukon, Northwest Territories, and British Columbia, the Nisga'a, Tsawwassen and Manoth are two small groups. They don't even show up on the map because they're so small. And that represents 40% of the landmass of Canada. There's a remaining 20% that they're trying to get Aboriginal title extinguished to now. Next slide, please. So this shows where the termination tables are taking place. It's a map that Aboriginal Affairs Canada has produced. You can see that British Columbia, Ontario, Quebec, and the Atlantic are the main areas where negotiations are taking place. Either comprehensive claims and or self-government, because if you're negotiating comprehensive claims, you can negotiate self-government agreements at the same time as a package. But some groups, like in Ontario, who have historic treaties, they're just negotiating at self-government tables. Basically, like I said, to have federal and provincial laws dominate over First Nation laws and to become a municipal level of government within the Canadian Federation. That's basically what the self-government policy allows. On the prairies, you can see that Manitoba, Saskatchewan, Alberta, there's not too many groups negotiating. I think Meadow Lake is one in Saskatchewan. Other than that, the Cree and the Saulteaux aren't really negotiating. It's mostly the Dene and the Dakota groups that are negotiating. But this map is on the Aboriginal Affairs website and gives you a good snapshot of the 99 tables there, with over 400 communities who are involved in those 99 tables. So the majority of the bands in the country are at one of these tables, and it affects mostly status Indians in Canada will be affected by any final agreements coming out of these tables. Next slide, please. So this is a list that I think we've got posted at the I Don't Know More website. It's from the Aboriginal Affairs website. This is just a screenshot of the title of it, but this lists which provinces, which bands, what they're negotiating, what stage they're at. So if you want to find out if your band is at a table, you need to look at this list. But basically the ones who are representing First Nations at the tables are the chief and councils. They'll have advisors, lawyers, staff, and they'll all be funded by the Government of Canada and the provinces to negotiate these final agreements that they're seeking from the different groups who are negotiating under these federal policies. Because both of these are federal policies, but the provinces involved because they have the lands and resources under Canada's constitutional structure. So if there's any lands to be given in the agreement, that they expect the province to agree to give those lands or resources. But again, because Canada has constitutional authority under Section 9124, that's why these are federal policies and not provincial policies. Because Canada has authority under Indians and lands reserved for Indians, and that's what they're using to push these policies. Next slide, please. So, turning the tables, what can you do? These are just some of my preliminary ideas. Like Shiri said, really it's up to us that want to get involved in this campaign. You can start by getting involved with I Don't Know More and Defenders of the Land, Turning the Tables campaign. This webinar is just to kick that off. It's really about self-determination, not termination. Right now, Canada's policies are based on an extinguishment and denial of our rights. What we want is recognition and affirmation, like Section 35 says. We want them to turn the tables on the whole objectives of what they're trying to negotiate at all of these termination tables. There's federal termination legislation, amending the Indian Act, and policies will negatively affect First Nation citizens, households, communities, and nations, all of our peoples. Next slide, please. So step one is you need to inform yourself, find out if your community is at a termination table, Find out what position, if any, your chief and council, your tribal chair, heads of First Nations organizations, AFN regional vice chiefs have taken on the federal First Nations suite of legislation and or these termination policies. Get more information and read it. If you don't understand it, find someone in your community who can help you understand it. Various First Nations organizations are giving out info on the threats that these new federal laws and policies pose for First Nations peoples. But I think first and foremost, I Don't Know More can help you. We're going to be talking about how we're going to do information sharing. Next slide, please. Step 2 is to organize yourself and others. Start networking and dialoguing among family members and other concerned community members and other First Nation citizens, communities, and organizations about the impacts of the termination legislation and or policies. Form working groups, distribute the info by photocopying, faxing, emailing, or social media if you have access to it. Think about events to make your views known to the wider public, and maybe have fundraisers to cover the cost of the activities. And you're also, I think we encourage you to link up with other First Nations allies and supporters where possible. I mean, I Don't Know More and Defenders of the Land are both networks that do work with non-First Nation allies and supporters. We think, given that we're a small demographic minority in Canada, we need to convince other Canadians to support us and help us fight this termination plan. Next slide, please. Step 3, prepare materials for media and public distribution. Try to get someone with media or public relations experience involved in helping to develop materials or use materials and advice from other First Nations peoples and organizations like I Don't Know More as a network. Prepare positive messages to counter the negative federal smear campaign underway. Monitor and respond to negative and erroneous media reports. Identify key spokespeople. Develop media contacts, hold press briefings and conferences, and don't forget to contact both Aboriginal and non-Aboriginal media to make yourself heard. Next slide, please. Step 4, take peaceful actions. We're encouraging, that your actions are peaceful. Remember that your message will be received and perceived better if you don't resort to violence. Some suggested non-violence actions to take are letter writing, faxing, email, social media campaigns directed to the Prime Minister, Harper, Minister of Aboriginal Affairs of Canada, Bernard Valcourt, the Standing Committee on Aboriginal Affairs and Northern Development, and the federal Conservative MPs and senators, because this is a focus on the federal government. That's where these termination policies are coming from. That's why I've suggested going after these politicians. Make sure you copy the New Democratic Party and the Liberal Party of Canada and your local regional First Nations offices, including AFN in Ottawa. Even though they're dysfunctional, it would be good to keep them in the loop and keep the pressure on them to make sure that they're on side and trying to stop this termination plan as well. They won't do it willingly, but with pressure from grassroots people across the country, the leadership won't have much choice but to support us. Next slide, please. And in that regard, you need to get your chief and council, tribal council, regional or treaty organization to pass a resolution opposing the federal termination legislation and policies. And I Don't Know More, Defenders of the Land, we can help prepare sample resolutions and information kits and send copy. And we ask that you send copies of whatever you do in terms of resolutions to the I Don't Know More website so that we can compile them and distribute them to a wider audience. Coordinate with local law enforcement while planning peaceful actions involving demonstrations at local federal government offices, offices of MPs, senators, or elsewhere. There are other things can be done. These are just suggestions. Next slide, please. Was that the last one? I think there was one last slide. Yeah, okay, that's it. Contact the opposition party leaders and Aboriginal affairs critics of the New Democratic Party and the Liberal Party and send them your information. It's up to you to turn the tables on Canada's First Nations termination plan. Really, my message to you is if the plan is successful, it will be difficult, if not impossible, to reverse the consequences and impacts on the daily lives of our peoples for generations to come. In my view, this plan is more devastating than the original Indian Act was when it was introduced. So we're asking you to join our efforts to stop it, because if it goes ahead, there's more tables that are signed off on our constitutional rights. It's going to be pretty devastating in the long run for our peoples. And already those groups that have signed off on modern treaties have had to organize this Land Claims Agreement Coalition because the governments aren't even respecting the agreements that they signed, and they formed their own organization to lobby to try and get the government to honor the so-called modern treaties. Anyway, that's all I have to say. So thank you very much, and I guess we can go forward to any questions or anything.
Russell, thank you so much. That's a lot of information to digest and so much valuable information for moving forward. I know you're always saying that in order to fight a good strategic battle, we need to actually know what we're up against, and you laid it out so clearly for us. If anyone missed something or wants to use Russell's knowledge in order to educate themselves or use them in classes or in communities, his presentation slides as well as a video of the presentation he just gave will be uploaded to the Idle No More page that's dedicated to the Turn the Tables campaign. So that can be found at www.idlenomore/turn_the_tables, where there will also be information posted about the termination policies, and some of the historical documents that Russell mentioned will be on that site, including previous efforts to fight the land claims policy. For example, following the Delgamuukw decision, Supreme Court decision in 1997. Other ways that you can get involved right now at this moment are to ask Russell questions, clarification questions. If you have that question, maybe other people do. And you can do that by posting a question on the Idle No More, on the Facebook event page, or on the YouTube event page. Or you can use the hashtag #TurnTheTables in order to reach out and ask your question, and I'll convey it to Russell so that he can answer. We already have a few questions that I'm going to read out. One of them is a point of information from Melissa Montour, who comments that Kahnawake is already headed down that road of municipalization through another form, which is a memorandum of understanding, and she posted a link to that. Someone asked, what does fee simple mean? Russell, you talked about the transformation of Aboriginal title or unceded traditional territories into fee simple lands, which is a requirement under the Comprehensive Land Claims Policy. Can you just say something about what fee simple means?
Yeah, basically that's right now reserved lands under the Indian Act are under Section 9124. The Crown holds the underlying title in trust, or as the fiduciary for Indians. But if those reserves are sitting on Aboriginal title lands, there's a whole issue there about the linkage of Aboriginal title to the lands that the reserve is sitting on. And there's also treaty lands. Some of these many of these reserves have been set aside as a result of treaty promises. And so fee simple is basically taking reserve lands which are collectively held. The only individual interest that's on a reserve under the Indian Act is a certificate of possession. Many of them are on my reserve in Kahnawake. You know, a lot of reserves in Ontario and that have certificates of possession, CPs they call them for short. That's about as close to individual ownership as you can get on the reserve. Some reserves, not all reserves have them. But what fee simple is, it's basically provincial lands that an individual can hold when they buy a land or a house in a city, like a house lot. That's the highest form of title that you can hold from the Crown as an individual Canadian citizen when you buy property. So if you have fee simple property, you're likely paying municipal taxes on it, like I am, because I live in Innisfil. And so the property that I own, or the bank owns, you know, is fee simple property. But on reserves, like I say, it's collectively held, and you know, you need to think about how the reserve was created. There's legal issues there. And in terms of what Melissa's mentioning, I'm familiar with that MOU that Kahnawake entered into. They're basically exploring what their options are, because Kahnawake has inherited the mess of the Indian Act with these CPs and what to do. There's toxic sites on the reserve, you know, that are environmental messes that they're responsible for now. They're responsible. They have a lands unit in Kahnawake, so they're responsible for settling survey disputes between neighbors who say, you know, this is my property, no, this is my property. Indian Affairs used to settle all that before, but now the band is in charge of that. So there's a whole bunch of issues that they're dealing with on lands and membership as well. You've probably seen Kahnawake been in the news lately about supposed evictions of certain people. You know, there's a lot of concern. There's the membership code in Kahnawake has been very strict, and I think it's tied to the concerns about losing land to non-members. So the membership issue is pretty much tied to the land issue in a lot of ways, I think, in Kahnawake, and other communities too, I think. But in Kahnawake, it's a large community, and there's a lot of pressures. And under the MOU that the government has signed with Kahnawake, they're saying they've got various tools to address it. One is the specific claims policy. Kahnawake is negotiating a specific claim for a big piece of land that's adjacent to the reserve that was originally part of the reserve from the 1600s. There's the additions to reserve policy. There's a new one that Canada's coming up with where they're saying bands can acquire lands for social or economic purposes. There's the First Nations Land Management Act, which basically allows you to opt out of the provisions of the Indian Act into that act and develop land registry systems, you know, where you can start registering individual interests. And in a way that could be seen as a transition to fee simple and merging with provincial systems. But a number of bands, I think 30 or no, over 100 now, have opted out of the Indian Act into the First Nations Land Management Act. And some think for economic development purposes it's better. But, you know, I think you need to think about the legal implications of that, because if your reserve, for example, was set aside by treaty under a treaty promise, and you're letting the government off the hook for any liabilities they may have for mismanaging your lands, and if you got toxic dumps there you don't know about, and you know you have to take those over under the First Nations Management Act because you're managing it, not government. So the government has all these tools, but they're all interim tools to manage bands to go in the direction they want them to go, which is to eventually become municipalities with fee simple lands. And those under the Indian Act, they're managing them on one track, and those who are in self-government or comp claims talks, they're managing them on a different track. But it's all to achieve the same destination. So I don't know, fee simple, you know, bottom line is it's provincial lands as individuals. It's not Indian lands anymore, or Aboriginal title lands.
Thank you, Russ. Speaking of Aboriginal title, we have a really urgent and pressing question that's come in about how do you think the Canadian courts have advanced or diminished First Nations rights? Do you think Canadian courts have legal jurisdiction to determine our rights? And if you can relate that question back to the termination policies in terms of what have been the discrepancies between what the Supreme Court has been saying, for example, in Delgamuukw and Chilcotin, and what the land claims policy is all about, that could be helpful, as well as, commenting more broadly on the question.
Well, I think the courts in defining Section 35, these two cases that just came down this summer, Chilcotin on the Aboriginal title and Keewatin on Grassy Narrows in Treaty 3. I think there's some troubling rulings in both of those, which I think threaten First Nations survival. In the Chilcotin case, although they recognize that the Honeycuttine of the Chilcotin have Aboriginal title to their about 1,700 square kilometers of their territory, they also said that the Radicor underlying title belongs to the Crown. The Crown has sovereignty. They reinforce, they're saying that if you're asserting Aboriginal title, and everybody is asserting Aboriginal title because Canada's only recognized one group in Canada that's established Aboriginal title, and that's the Chilcotin. Everybody else, the court says, is asserting title, and you have to go through a process either through the court or through an agreement to get Aboriginal title established or recognized. And if you can get it established, then your consent is required. But just like with fee simple lands, which can be expropriated, they're saying Aboriginal title lands can be justifiably infringed for valid reasons. And they compare Aboriginal title to fee simple lands as a property right. But they don't address Chilcotin jurisdiction in there, so that leaves the self-government policy unchallenged. And they don't deal with the, Chilcotin, how will Chilcotin laws and jurisdiction apply in that territory. So that's where the federal government is still going to be pushing that 1995 self-government policy, and they're going to be doing that with historic treaties as well, because in the historic treaties, the courts have basically said they've given up their lands, before 1982, so they basically extinguished title through historic treaties. They've ceded, released, surrendered them to the Crown in exchange for treaty promises. We see in the Keewatin case that they're saying that, and that the federal and provincial orders the government have, the responsibilities, the provincial governments have responsibilities over natural resources. They're saying Section 109 of the BNA Act, which transferred lands and resources to the provinces, is in place. This 1930s Natural Resources Transfer Agreement, which affects Manitoba, Saskatchewan, and Alberta, is in place. So that puts the historic treaty groups in a really difficult situation, because legally it doesn't look like they have any recourse to challenge that constitutionally, because the courts closed the door on them. So really, I think it's only a political challenge that they can make at this point, because it's an immoral, unjust position to take, that the Indians on the prairies and in the numbered treaty areas don't have rights to lands and resources like those from Aboriginal title lands that do. But in either case, Chilcotin and Keewatin reinforce the existing federal and provincial orders of government. Burden of proof is still on the groups who are asserting that they have Aboriginal or treaty rights, and like I said, the legal tests mean millions of dollars to collect the evidence and to prove it. Do I believe that the courts have the right to define our rights? Well, the Canadian state is what we're up against. And I don't think it's fair and just that they're doing it, but within their system, they're dominant, and that's why I think we need to create a political movement with Canadians to help us to fight the system back, because it's not going to change. We're not going to get fundamental restructuring of Canada by ourselves. And we've got a big mountain to climb, because I showed you a map of all the communities that are caving into these termination tables and agreeing to sign off on these the terms that Canada is asking, the preconditions that Canada wants. The more groups that surrender to that process and to final agreements under those policies and to the legislation, the harder it's going to be for those who are resisting. In a way, it's like those on the prairies that didn't sign treaties and became adhesions to treaties, they basically were starved into submission. I mean, there's a new book out called Clearing the Plains, which documents that whole history of, you know, Sir John A. Macdonald using the starvation as a serious policy from Ottawa to force Indians into submission to sign treaties. So, I mean, we really need to know the historical context of this termination plan that Canada is using on us to basically to finish us off, because we're at the end game now, in my opinion.
Russ, there's a lot of specific questions about Ganawage, the treaties they've signed, about the First Nations Land Management Act, and I'm going to get to those in a minute. I just want to stay on the termination policies, make sure I speak specifically to those because of the nature of the broadcast. I'll read out, there's a comment that says, I implore First Nations who are dead set in pursuing termination to ensure capacity is built in-house so your nation is not run by outsiders. There's a few questions along this kind of train of thought around what does sovereignty mean in light of these termination policies, and how can it be protected within Canadian Confederation. So maybe I'll try to generalize those questions by asking you to speak about you know, to think strategically, to help us think strategically about this problem that you raised as well in the two Supreme Court decisions that came down, where the governments aren't really making any room for Indigenous people to assert their jurisdiction. You know, it's they're either under 9124, which is the federal government's jurisdiction over Indians and lands reserved for Indians, or in Chilcotin, the provincial government is given a lot of power to infringe on Aboriginal title. Section 35, you talked about in your presentation, was supposed to create a space for Indigenous people to, you know, to affirm their Aboriginal rights and treaty rights. Really what you're describing is a kind of black box where there is actually no legal space. This is maybe what you're defining as termination. There's no legal space left for Indigenous people to assert their jurisdiction and self-determination. When they do it on the ground, they're criminalized and are subject to a militarized response, as we saw in Elsie Pug Tug. So what does asserting sovereignty and jurisdiction look like now in the face of termination? What kind of movement needs to be built? What does sovereignty look like? And is there any hope in Chilcotin? Is there any hope in these legal, within the Canadian Confederation to make any space for Indigenous people? Or do you think kind of outside of those? Do you think people need to think outside of those structures?
I think legally it's going to be very difficult unless you have your research completed. You know, all the to meet the legal tests about Aboriginal rights or treaty rights or Aboriginal title. Just, you know, and to be able to afford the costs, you know, of mounting a court case and paying the lawyers' fees and the court costs and everything. It's going to be difficult to achieve justice, because I know most bands in the country don't have that kind of money. Any monies they have coming in from the governments, it's got terms and conditions, and you can't sue the government with it. And the government knows that, which is why they come and say, well, we're ready to negotiate, but the negotiations are all one-sided. The yes side is funded, the no side is not funded. We're on the no side, we're not funded. But the yes side has got, you know, tens of millions of dollars every year, you know, to go along with the government. The government's basically paying them to stay at the tables. To me, sovereignty is the will of the people, basically. And it's the will of the people. What do they want to do? Do they want to resist and fight and try and protect future generations' rights? Or do they just want to give in and, you know, sign off on these agreements and see what they can get for this generation and let the future generations sort it out amongst themselves, whatever's left under Canadian law? You know, the situation you know, we have in Canada is that that self-government policy is an interpretation of Section 35. They're saying, you know, Section 35 doesn't recognize self-government, so you have to negotiate with us some delegated authority. Some groups, you know, are trying to say it's restoring jurisdiction, but it's not. It's, you know, it's negotiating delegated authority from federal and provincial levels of government, depending on what subject you're dealing with. And the issue of self-determination. Art Manuel has raised this. He said that Canada appeared at the Human Rights Committee, I think, in 2007, saying that Indigenous self-determination is included because Indigenous peoples are part of the Canadian population. So that's what they're saying internationally, is that the international covenants of the United Nations on human rights regarding the right to self-determination for Indigenous peoples, you know, we're Canadians, so we're included. So they're not recognizing us as having a distinct right to self-determination as Indigenous peoples, you know, the Canadian government. So politically, legally, we're closed off, as you say, in a lot of ways. And really that only leaves the political and social option for us is to get together collectively. The Assembly of First Nations and the provincial organizations and them, all these executive type chiefs that the chiefs elected and not the people, they failed to address these issues. And that's why I've said, you know, the only hope we have now is in the people, because if the people don't get it together to do something collectively and force the leadership to coordinate and move forward towards the government instead of towards us, because mostly I'm seeing the leadership trying to shut us down to keep going along with the status quo, because they're all getting paid, you know, every 2 weeks to be at those tables and to go along with what the government's saying until they think the conditions are right, you know, to reach a final agreement and get a ratification process from their members. I think we have to turn that around and create the conditions in the country for our peoples to be able to be recognized as a distinct order of government. In fact, in 1983, there was a special parliamentary committee on Indian self-government called the Penner Report, after Keith Penner, the chairman. And that's what that report recommended. You know, the Conservatives, the Liberals, and NDP all agreed. They said that First Nations should be recognized as a distinct order of government in Canada, and you know, that they should be having fiscal arrangements in that, and lands recognized, you know, as a distinct order. And so Section 35 should open up a space in the Canadian Federation for a distinct order of government. But you know, the debate at the constitutional tables didn't allow for that. After those tables ended, you know, Canada has come forward with this negotiation policy where they're saying, come on down, you know, we're ready to negotiate. But, you know, we have to look at the long term, I think. You know, if we have any, you know, I'm a grandparent. I'm thinking about, you know, the grandkids and what are they going to have as, left as rights. And it's looking pretty bleak. If we don't do something in this time now, 10, 15 years, 20 years, there probably won't be anything left by, you know, the next 2 or 3 federal elections. You know, we'll be in pretty dire straits.
Thank you for that really great answer. So a very hard question. There's another question that's come up about that deals with natural resources that also you have special expertise in, Russ, that I think you could speak to really well in your work with Wolf Lake and the Algonquin Nations more generally. And the question is, areas like Aamjiwnaang, Fort Chip, Grassy Narrows all show how there's a significant double standard towards the protection of human health on First Nations reserves via the rest of the Canadian public. Laws against pollution are weaker because provincial pollution laws don't apply on a res, since it's federal land. Industry sets up shop next to reserves because they won't get fined the same. The result is more of our people are actually dying. They're poisoning us off the land in many areas. It seems every time we use the courts to do battle, a new battleground shows up with the same issue. How can we fight this? Can we work with provinces to bump up protection for all folks within provincial territories?
You know, I wish I could give better answers, but look at the situation in Grassy Narrows. I mean, they've been poisoned by mercury pollution. Their human health, you know, they're suffering degenerative disease to their nervous systems. Pig Harper in Nova Scotia. I mean, when I went there, I was just totally, I couldn't believe that was even in Canada. they've got a pulp mill there that's spewing out effluents into the waters and air. The reserve next to them, they're having birth defects and other health problems. Look at Yellowknife, that gold mine with arsenic in that. They're saying it's going to cost $1 billion to clean that up. And, nobody wants to pay for it. The feds don't want to. Territorial government says they can't afford it. Yet the Yellowknife Dene are the ones saying, well, we're left, it's going to affect us for generations to come. And these examples are, for the most part, off-reserve examples. But on reserve, this is the other thing I was saying about, the First Nations Land Management Act, for example. They're asking you to take over the management of reserve lands, but you better check and make sure you're not taking on liabilities of, in PCB barrels being dumped underneath the ground somewhere that you don't know about from the 1950s or 40s or 30s, This generation doesn't know exactly where a lot of those things are, and a lot of reserves have these kind of environmental problems. So I agree, that there is a double standard, but it's not just on reserves. I think it's a treatment of Indigenous peoples and resource lands in general. I mean, that's what that omnibus bill that Harper passed, was relaxing the environmental regime for environmental assessments, so that they could promote business more and not have the regulatory red tape to slow down the approval processes. They just want to be able to get at the natural resources as quickly as possible. And now you look at this tailings pond spill in BC. This was they were warned about this years ago before it happened. So all of this goes to show you that Canada has been relaxing the environmental regime in general. And I think for First Nations, because they are in more rural and isolated areas where resource development takes place, they're experiencing a lot more of the front end of it. What do we do about it? Again, with the tar sands, the pipelines, all the stuff that's planned to go through, we have to be vigilant and hold these governments to account to make sure that they're not relaxing the regulations, and look at what we can do to try and stop and have a say in this development. Because if we want sustainable development and clean development, then we have to be responsible and get out there and do something about it, and not expect somebody else to do it for us. Because it isn't happening.
Yeah, right. Thank you for that answer. I Don't Know More is urging me to remind people to go to the website for more, to check out resources and to find out more about the campaign and stay tuned to that campaign. So that website is www.idlenomore.ca/turn_the_tables. We have a lot of really, really good questions coming in. One question here is, some communities are entering into agreement because they feel that if they don't, we will be marked as extinct within a generation, according to Blood Quantum. Hoping Russ Daibo can give us some insight into the nature of this ruling by the government. And that also speaks to a bigger question about why communities are signing land claims agreements and or entering into reconciliation or recognition agreements as well. What kind of larger pressures are pushing bands into this termination? If you want to try to respond to that.
Well, I think it's because, we've been in a situation of underdevelopment. The Indian Act has, controlled us. Any economic development that competed with white people, was always under attack, I always like talking about Guanawagi. I saw a historic document from the 1830s where the French farmers were complaining that the Mohawk farmers were bringing pig manure to Chateauguay, the town next to the reserve, to sell as fertilizer at a price cheaper than them. And they were complaining to the white government that they wanted them to stop the Indians from doing that. So I've always said we couldn't even sell shit without them complaining. And now they're complaining about cigarettes, right? Because they're not collecting the tax. And then there's a book called, I think it's called Lost Harvest or something like that by Sarah Carter, about the Qu'Appelle Valley area, where where my wife's family and and my in-laws are from, and they were becoming good farmers, even though they were buffalo hunters before that. And they were competing with the white farmers, and the white farmers complained because you know, the Indians were going to agricultural fairs and figuring out the seeds that were coming in, and that was when farming was getting mechanized, and they were looking at the new technology, you know, for tractors and things like that. So after the whites started complaining, that's when they started to impose these pass laws saying you needed a pass from the Indian agent to go off the reserve. And they wouldn't give them to them, and the Indians fell behind, and they just gave up, you know, trying to continue farming, and they wound up leasing their reserve lands to non-Indian farmers. Again, it was because of the competition. They didn't like it. So reserves were set up to keep us, you know, corralled while they benefited from the lands and resources that they took from us, which we're still entitled to compensation for, I think. I mean, we've subsidized the Canadian economy through these stolen lands and resources, which they're keeping. And, you know, the Canadian economic development plan, like a lot of the bands want to get into economic development. They got young growing populations, and they're focusing on jobs. But what they're winding up doing is training, you know, individuals to go for jobs to work for these corporations, you know, like the tar sands companies or the pipelines, and, you know, these resource extraction companies that we're complaining about that we have no say over. And these are on our Aboriginal title or treaty lands that this is happening on, and we're not getting resource revenue sharing, and we're not getting co-management or accommodation into having a say in how development occurs. They're forcing us into a track as individuals to seek jobs to work for these corporations. And, you know, a lot of the bands are going for it because the government's closed off all their other avenues, their options. You know, they're saying this is your only way out if you want to improve, you know, the employment in your community. That's why they put money into training, and they encourage people to move away from home and find where the jobs are, just like the white people do. Mm-hmm. You know, and that's the reality of it. You know, is if we want to develop our own economies, I think we have to talk about how we were systematically underdeveloped by the Indian Act and prohibited from developing, which created the poverty that exists in our communities now. And they're trying to tell us the only way out is the way that they'll decide, and they'll license and permit us out under their rules. And so if we talk about self-government and managing our lands and our access to our natural resources, that's when we get into conflicts with the provinces and that, because they're saying it's their lands. Right. You know, once we set foot off reserve.
So you're speaking to this paradox in the last 200 years of Indian policy, where on the one hand, the government has been demanding that Indigenous people become self-sufficient and financially independent, while at the same time pursuing aggressive policies of dispossession from land and resources. And that's, right now, we're looking at the legacy of 200 years of this contradictory policy, and people are asking now, people are generally asking, but people are actually also asking in the questions, you know, what are the alternatives? What does an Indigenous economy look like outside of this kind of economic development model? How would revenue be generated within you know, an Indigenous sovereign framework, as opposed to within the federal and provincial models and under their jurisdiction and decision-making powers?
I don't think there's any one answer for that. I know that Canada's approach has been to promote economic development, and they've used 4 main bands in BC as the models for development, for reserve development, and that's West Bank, Musqueam, Squamish, and Kamloops. And those bands are all next to urban areas, so they can treat their reserve lands as real estate. You know, these bands go into long-term leases with non-Indians for residential purposes who build houses on there for 100-year leases. You know, West Bank is in, you know, they got a 4-lane highway going through their reserve with big box stores and everything on there, and they're collecting, you know, tens of millions a year in taxes. So they're benefiting from that kind of development on their reserve. But many of the rural and isolated communities in Canada, that kind of model is not going to work for economic development. and that's where the resource extraction's taking place. And I think, how do you develop a model on that? Well, it's pretty hard to do when they won't recognize that you have Aboriginal and treaty rights to those lands and resources in the first place. They try to limit to hunting, fishing, and trapping and gathering, and they don't want to, any argument about commercial rights. They want to limit and restrict and say you have to assimilate into the general economic system of Canada. That's how come they're always holding up Clarence Louis as a poster boy for economic development, because he's got his winery and his other developments. He's also geographically located in a nice environment in the southern Okanagan Valley, but he also shuts up about rights. He just operates within the existing economic system of the province in Canada. He even agreed to have a provincial prison built on the reserve lands, and there'll probably be a lot of Aboriginal people from BC in that prison once it's built. But I mean, he's the guy that they're promoting, because that's what they want other leaders to do, is to shut up about rights and talk about how can they start working with the corporations and get with the program. That's what the development models are about. They don't allow us to develop an alternative. I know when you start talking about these to these chiefs at these termination tables, and they're saying, well, what's the alternative? But that's the point, is they don't work on an alternative, because they're all marching on to Ottawa's direction to go the way that Ottawa's telling them to go, because they've all been trained by the government to internalize the funding criteria of Ottawa and the rules of Ottawa and follow those if they want to get any recognition from Ottawa and agreements to work on their projects. But that's where I think, if we want to develop alternative development models, then we're going to have to start doing it ourselves, because if you look at all the conferences that are funded by the government, it's all to support what they want. AFN had a big conference with Aboriginal Affairs a few months ago. What was it about? It was about infrastructure, water and sewer. Why? Because they passed a law on national standards on water systems on reserve. So now they're telling them, okay, they're training the bands, this is what you have to do now, which is part of municipalization. I mean, I'm not saying, having good water systems is bad, but it's within the framework of what the government wants bands to do, which is a focus on local governance matters. Don't talk about nationhood or working with other bands to form broader regional networks and plans. We want you to focus on local issues, just like a municipal government. That's what the bands were set up to do under the Indian Act. And, the development theorists say, the problem with trying to develop lands and resources and infrastructure after is that, in our case, the Canadian state developed everything around us. We were set aside on these reserves, the leftover lands, some say, and they've taken the best lands and the best areas for development, and now they're expecting us basically to just fit into the towns and cities that are there now. So we need to figure that out. One of the things that I do know is we need to use the tools available to us, and one of them is computer mapping. We need to start mapping who the interests are around us, who's on our territory, what they're making, and figuring that out so that we can start going after them and saying they should be paying us instead of the governments. But that goes back to, we need to start collecting information and be organized about it, and then we need to act on it. But that's a whole nother story. That's a big question to talk about alternative economic development models. You need information, though.
So we're just in the last few minutes here before we wrap up, and a lot of really good questions are coming in at the end, and I'm going to mention them and kind of bookmark them for future discussions, or also for other people who may have similar questions. Maybe we can post stuff to the website, www.idleknowmore.ca/turn_the_table, so that we can continue this discussion. So one of the questions is asking whether Mulclair, leader of the NDP, could be an ally in this struggle against termination. There are questions about, more questions about alternatives and what they would specifically look like. How this affects Indigenous people living off reserve determination policies. But the question that I want to end on is a question from a young mom, Janelle, who says, Russ, how can we teach our people about our rights when our reserves are more concerned with survival? Aboriginal title, for example, is not even a thought in your minds. And I know you've thought a lot about this because you work on the ground and you can see what reality is every day for people. And these may seem like really high-level problems, but they obviously affect people dramatically in their everyday lives. But people who are fighting for survival may not have the resources or the capacity to get involved in coordinated campaigns, for example. So what kind of efforts will Idle No More and Defenders of the Land, for example, be making in order to really try to ensure that this is a grassroots struggle that speaks to people who are fighting on reserves on a daily basis for survival?
That's a really good question. I mean, the reality of it is the Indian Act took away our choices for generations. Even the choice. I think it's an unwritten part of the policy of Canada to make conditions on reserve so bad that people are moving off reserve into cities and towns because then they become a provincial area of responsibility, and they don't have to pay for the programs and services the province does. That's why they're not, creating new houses. They're not investing in infrastructure. I'd argue that's why the school systems are underfunded. It's because they're trying to encourage migration off reserve because the objective is to get rid of reserves. In treaty areas where the reserves are set aside through treaty promises, it's harder to get them to agree to initiatives like the private ownership initiative to turn reserve lands into fee simple because they know the reserves were promised to them in perpetuity. In other areas where the reserves are set up differently, some are looking at saying, well, maybe we should just break up the reserve land holdings and give them out to individuals through fee simple. Some have already made that decision. The Nisga'a did, Tawasin did, Manoff did. Others are actively extinguishing in the BC treaty extinguishment process. So they're obviously deciding to go down that path to assimilate into the broader provincial system. But the poverty that we're experiencing is a systemic thing, and we have to figure out how we can help each other get the information we need and figure out what actions we can take together to support each other, whether we're members that are living in the city or in the reserve. I mean, in a way, that's why it's a good complement between Idle No More and Defenders, because Defenders of the Land Network represents Indigenous communities who are land-based in their struggles, fighting with different resource developments. And Idle No More, not all, but a lot of people came from the urban areas, who come from communities and have family and relatives there and supporters who recognize the wrongs that the Harper government was doing. So in a way, the two networks complement each other in addressing the urban and the community level issues, and hopefully we can continue to do that. And anybody that needs information or is asking for some kind of help, maybe that's something we can do through the social networks that we have, is to try and help communicate that and link them up with people that might be able to help them locally in some way. It's mutual support. If we don't help each other, we're not going to get anywhere. That's and like I said, the chiefs haven't been able to do it, so it's really up to us now, I think, to show some leadership, and as parents, and as relatives, as friends, we need to start working together in a broader social and political movement to just, and this is going to go beyond the next federal election. This campaign is a long-term campaign. It's not going to change overnight. People need to realize that Justin Trudeau is not going to save us. Thomas Mulcair is not going to save us. If anything, they're going to be a variation of Harper. They might be a friendlier, smilier one, but in the end, the economic interests are so great, they're going to try and keep, what they've taken without sharing it with us. We're going to have to struggle to get our share of what they've stolen.
I think that's a great place to leave off on. There's questions that have come up around UN DRIP and broader questions about self-determination too, and I know that there's talk about having a follow-up webinar about the international context of self-determination, but I can't think of a better foundation than the one you provided, Russell. It gave us such a clear understanding of the domestic policy, legislative, and legal frameworks and constitutional frameworks that have collectively created what you're calling the termination tables and termination policies. So we'll leave it here for tonight. Thank you to all the Idle No More volunteers and support and leadership that helped make this call possible, and to Defenders of the Land too for all their input on what content we should present. And thanks so much to all the questions that come across the country. Sorry if we didn't get to all of them, but specific questions we'll try to put more information, we'll try to respond to rather through the website, www.idlenomore.ca/turn_the_tables. If you have any comments about tonight's presentation that you want to put on Twitter, you can use the hashtag #TurnTheTables. And I think that's it for us. So thank you again to everyone for joining us, and most of all, thanks to Russell Dibo for, people are saying, I'll just quote them instead of myself, it was a clear and powerful presentation. People learned a lot, and they're very thankful and grateful. So thank you so much to Russ for putting so much time into educating people on these issues. And good night to everyone.
Yeah, thank you for everything. I don't know more than everybody. Yawakoa.